You're welcome back. Now, General Manager of Talents Discovery Limited, Thomas Amoah, was on Friday interrogated 4 hours by officials in the Special Prosecutor's office. He was accompanied by part owner of the company and suspended CEO of the Public Procurement Authority, Ejeni Mboating Ejay. Mr. Amoah was captured in a documentary by Manasseh Azura when allegedly selling government contracts. JoyNews' Joseph Akablé on Friday pitched camp at the office of the Special Prosecutor as day 2 of interrogations continued. Here is his report.
PPA CEO Ejeni Mboating Ejay, Thomas Amoah, who is the General Manager of Talent Discovery Limited, and Francis Ahin, who is a shareholder of the Talent Discovery Limited company, together with their lawyers, came for the second phase of the interrogation on Friday. They arrived at the premises of the Office of the Special Prosecutor at about 9 a.m. At 9:30 a.m., they exited the office as they were led by investigators to visit various locations that we understand forms part of the investigation as the investigators seek to carry out some verification. You will recall that on Thursday, when the PPA CEO arrived, he was charged and granted bail as well, after which he told pressmen that he had done no wrong. But obviously, investigators are continuing with their work to attempt to unravel all the issues surrounding the alleged sale of the contracts. And so they left the premises of the Office of the Special Prosecutor at about 10 a.m. to carry out the first phase of the verifications that we understand took place outside the offices. They subsequently returned later on, only to leave again at about 10:30 a.m. on a Friday as they continued with the investigation. And so that formed the second phase of the investigation that saw the investigators interrogate Francis Ahin, Thomas Amoah, and Ejeni Mboating Ejay. What is not so clear is whether this investigation or this aspect of the investigation will continue beyond Friday. But what we can be sure of is that the Office of the Special Prosecutor has already indicated that they are looking into this matter. You recall that when the President referred it to them, they had indicated that they should expedite their investigation. And so the expectation is that once they conclude investigations, they will inform the general public that has taken a keen interest in this particular matter as to the next line of action. And so this is the situation here at the Office of the Special Prosecutor. Reporting for JoyNews from Laboni, my name is Joseph Akablé.
Well, Martin Pebu is a private legal practitioner, and he will help us appreciate the law better on contract subletting and contract sale, as well as when it becomes a procurement breach. Mr. Pebu joins us via Skype. Many thanks for your time, sir.
You're welcome, Gifty.
Right, I'm sure you've been following the discussion since it broke and the subsequent commentary on the issue. First, let's clear the issue about contract sale and contract subletting. What is the difference between the two?
Okay, so the contract subletting is what is commonly referred to as a contract sale. Now, what it is that this is a situation in which a person wins a contract from a procurement entity. So when we say procurement entity, it means the ministry, the agency, or district municipal assembly that awards the contract. Okay, so the person who wins as a contractor and subsequently finds that for so many reasons is unable to fulfill the contract. So he finds another person and transfers his rights to that person. So that is what is generally called the contract subletting. So that's 100%, which some call contract sale. Now, contract subletting per se is not against the law. To see whether somebody has breached the contract or not, we'll have to interrogate the specific contract. So let's say if there's a contract between District Assembly A and Mr. X, inside the contract, they will stipulate whether Mr. X is allowed to subsequently sublet or assign his interest or subcontract. So if they allow it, they may say so expressly. Or if they don't and they are quiet, if Mr. X wants to sublet, generally, all he has to do is to go and seek the consent of the procurement entity. Others will call them the employer, that is, say, the person who gave the contractor the contract. So generally, Gifty, the subletting or contract sale, unfortunately, though it carries some moral decadence, so to speak, like the way the general public is abhorred by it, it's legal, actually. I know, well, there are times that something may be immoral, but it is legal. You say, yes. So subletting is not against the law per se. It all depends on what the parties have written. Now, when it comes to subcontracting, what would happen is that sometimes the person may say, okay, let's say maybe he has to do A, B, C, D. So let's say there's a contract to buy chairs, tables, and let's say computers, laptops. Then the contractor finds that he can handle the tables and chairs, but he doesn't have capacity for the laptops. So he can subcontract part of the contract, not all, so that he performs part, then he gets another person to perform the rest of it. So generally, these happen. So, and this is general discussion, but to see what specifically, if anything, went wrong in terms of subletting, we would have to see those specific contracts. When I was contacted for this interview, I asked your colleague if you guys have laid hands on the contract. I was promised that it will be a copy will be sent to me, but as of now, I've not seen it. So when we see the contract, we can do a subsequent discussion on it.
Right. So subcontracting and subletting are not necessarily illegal, but at what point does it become a matter of corruption or crime?
Yes, you've put your finger right on it. Yes. So as to that, then you're looking at the influence of the person. So did the person who got those contracts, did he use influence, money, or any other illegal means to acquire the contracts or to obtain those contracts or to win the contract? So that is the question. And that is where you and I, well, at least, or maybe let me say, speak for myself, we don't have enough facts to be able to nail that question. Maybe the investigations will uncover. But of course, let's quickly add that we all know that a man is innocent until proven guilty, as stated in our constitution, because we have to be seen not to be trying him on air. Okay, like we say, media trial. No, we are just trying to educate ourselves. But the evidence, I haven't seen the evidence to be able to answer that question.
Jay himself has said that he's being made to pay for a crime he did not commit, and that his lawyer, Augustine Obuo, is on record as saying the PPA boss cannot be made to pay for the mistakes of crimes committed by a clerk or a manager of his company. What's the position of the law on that?
Okay, yes. Under our law, a company can be held responsible for a crime. Yes, earlier on I was saying that, you know, one of our former first ladies, Nana Kunedu Adjuma Rawlings, you know, just before President Kufuor left office, she was standing trial, and one of the companies carried them. Was also an accused. You see, so the company was also standing trial. So what I'm saying is that under our law, under certain circumstances, a company can be tried. But of course, because the company is not a living human being, it will be represented by the directors. Even we have another very recent example, the Muntie 3 example. You know, in the Muntie 3 case, the radio station that, you know, was used for the unpardonable words and that offense of contempt was hauled before the court. So it was the directors that came and stood to personify the company, because we all know that a company is not a living human being. So when there is evidence to justify the trial of the company, yes, under our law, it is allowed, and the directors will be made to stand in for the company.
Kwebu, I've also heard Mr. Augustine Obuo say that a receipt bearing the company name, which was issued to the investigative journalist, that's Manesse Azuri Awene, is not enough evidence that the money was paid to the company. It beats my imagination. What more evidence will be required as proof that money was paid to the company?
Okay, so basically, we may have to check, yes, receipt. Now you would have to inspect to see, does the company have such a receipt book? And you know, ordinarily, a receipt book comes with serial numbers. So the receipts that Manasseh is holding, we'll have to check, as a company got such receipt books, then we check the serial numbers. Now, that apart also, you may, if you have concrete evidence that that money was subsequently deposited in a bank, there is a way to subpoena the bank to provide provide the court with the bank statement of the company. So there's a way to go about it. But first of all, to ask a bank to bring the statement, you must lay the necessary foundation. The law frowns on just a fishing expedition. You just say, oh, the company has accounts, so straight away, let's bring them. No, you don't bring the bank easily. The law says that if you want the bank to come, you first must establish reasonable basis. The court will have to be convinced under Section 176 of the Evidence Act. Yes, bankers are asked to come to court as and when there is sufficient basis to call the banks to a bank to come to court and to furnish the court with the bank statement of an accused person or an accused company. It's all about the evidence. So, Gifty, it's all about the evidence as a prima facie. Let me use it in inverted commas here. It's all about laying a prima facie case before the court will make such an order.
All right, I'm grateful for your time. That's a private legal practitioner, Martin Bebu there. You're still watching JoyNews Prime. We're taking a breather.